New at 5, we're clearing up confusion surrounding the legal disagreement on voters' voices being heard. Yesterday, we filled you in on the groups behind the medical marijuana and Polk County casino amendments joining the lawsuit against the Arkansas Secretary of State ahead of the November election. That lawsuit was originally filed by the group behind the abortion amendment. As the Arkansas Supreme Court deliberates on a decision, we continue to break it down for you. 5 News reporter Kayla Davis is here. And Kayla, the two groups joining this legal fight are doing so under a different law.
That's right, Alexandra. This is a super complex issue, but we're here to help you understand it. While all three groups are now plaintiffs in the same lawsuit, the abortion group is battling the accusation that they did not train their paid canvassers, while the other two groups are battling the accusation that they did not background check their paid canvassers. Let's take a closer look. The group behind the abortion amendment, Arkansas for Limited Government, or AFLG, filed the lawsuit back in July after Secretary of State John Thurston refused to count their petition signatures. Thurston originally claimed AFLG did not provide a list of the paid canvassers by name or signed affidavits, sparking the lawsuit. Since then, the Supreme Court ruled AFLG did provide those documents and Thurston must count the signatures, but only signatures collected from volunteers. That leaves the signatures collected by paid canvassers uncounted. Now, Attorney General Tim Griffin, who is representing Thurston in this case, argues the abortion amendment is not valid because paid canvassers cannot sign off on any documents related to their petition. In this case, it was a paid canvasser who confirmed AFLG's paid canvassers received training. Because of that argument, both the casino and marijuana amendments have joined the lawsuit. They also had a paid canvasser sign off on their documents. In their case, it was a paid canvasser who confirmed canvassers received background checks. Both the casino and marijuana ballot items have already been certified, but if the Supreme Court rules in favor of AG Griffin and Thurston, that could mean all signatures collected by paid canvassers would be null and void, regardless of the original approval. If that is the case, both items will have to be removed from the ballot because they would not have received the required amount of signatures from each county.
So Kayla, this all comes down to who is or isn't allowed to sign off on the documents about canvassers paid to collect those signatures.
Exactly. This is similar to saying a candidate that's running for office can't hire an accountant to file their finance reports or a lawyer that can't sign off on any of the documents on behalf of the campaign. And one of the representatives from the group that's backing the casino amendment says this hasn't been the norm for multiple election cycles. Here are the two statutes the Attorney General is arguing in this case. The first you're looking at on your screen is what they're using in the abortion case to argue that sponsors must sign off on that paid training. And the following code is what's being used to argue sponsors must sign off on the background checks. With that being said, all amendments must be certified by August 22nd. For the specific statutes the Attorney General is arguing and more information on this case, check out our website at 5newsonline.com. Kayla Davis, 5 News.